Number 208, the people of the state of New York versus James Miller. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court, Daniela Main of Alston and Bird, in conjunction with the Office of the Appellate Defender for the appellant, Mr. James Miller. We request 2 minutes for rebuttal, please.
You may have 2 minutes.
Your Honors, the constitutional right to a jury trial means nothing without a fair and impartial jury. The trial court here deprived Mr. Miller of that right when it shut down his one and only opportunity to ensure that the jurors in his case could apply an incredibly difficult law on the single most incriminating and powerful piece of evidence against him.
But what would the question have been?
The question that counsel asked the court to pose was, can you instruct the jurors, or I could do it, that there are rules that relate to the use of a defendant's statements. And he specifically wanted to wean out any jurors who could not or would not accept the proposition that that you would have to disregard an involuntary confession.
I couldn't tell. Was there a suppression hearing in this case?
No, Your Honor. There was a Huntley hearing beforehand, but where a defense, did reference the voluntariness, that it would challenge the voluntariness of these statements if they were to come in at trial.
You moved to suppress the statement as being involuntary?
We did challenge the voluntariness of this, yes.
And you lost?
Well, there was enough reasonable doubt. I mean, the statements were voluntary enough beyond a reasonable doubt to come in and be an issue for the jury at trial.
Right.
But going back to the question, I read then the judge's ultimate charge on that issue to the jury, and it's pretty extensive on what involuntary means. So I'm having some trouble envisioning in a voir dire, which is relatively short process, but what would the articulation of a question be that could it capture what is a pretty lengthy and technical legal instruction?
Your Honor, the judge could have said, I don't know what evidence is going to come in at trial, and I don't want you to speculate about this, but there are rules under the laws of New York for how you can consider a statement that is made by a defendant. Could you apply the principle that, under our laws, a statement that is coerced cannot be considered as evidence for any reason?
Where do you draw that line, though? I mean, is it just confessions or statements of the defendant? Or could you say, there's going to be evidence brought in by the people here, but the main complainant has psychological problems? And will you keep an open mind, when I question him or her about the fact that they've seen a psychiatrist for 6 months, can you, or is that going to make it unable for you to sit as a juror? Can you ask that?
If the mental fitness of the defendant is an issue at trial, then presumably this would apply to that too. We're not arguing.
Complainant. I'm saying you're attacking the people's case.
If the complainant does have some mental issues and that is an anticipated defense to challenge that, then arguably yes. But when you have
and if they have a person who is a claimed eyewitness, but you're going to have testimony that that eyewitness did not have the point of view and did not have the time to make a good ID, can you bring that up in jury selection?
Well, Your Honor, that wouldn't be a law that has to apply to that. That's just basically the jury deciding whether they believe the testimony of that eyewitness.
Well, we have some case law that says that that eyewitness testimony has to be scrutinized very, very carefully, because particularly if it's a one eyewitness.
Sure, and so whether they could apply the law to evaluate witnesses' testimony, yes. But when you're talking about getting into the specifics of the facts of the evidence that's going to come out in trial, that's not appropriate for voir dire. But that's not what defense counsel here was trying to do. He was not trying to.
My understanding of what was happening here is that the people had not decided whether to present or submit the statement to the jury at the point where this voir dire was going to have to happen. And the judge apparently made a ruling that he didn't want to taint the jury because the statement may never come in. So if that had not been the case, it was clear that the statement was going to come in would you be able to, or ask, or would defense counsel be able to ask the questions that your client wanted the jury to hear?
Your Honor, the scope of voir dire and, what is appropriate on voir dire is not determined by the prosecution, and it's not determined based on the prosecution's stated level of certainty. And it's important to note that the prosecution merely said that it was not definite that these statements were going to come in. That could mean anything from probably to almost certainly will.
Well,
And
the
here-
prosecutor didn't mention it, right, in her opening, correct?
Did not mention the statement?
And that it was going to be she didn't, we know that prosecutors have obligations in opening statement, right? You have to mention that, talk about the nature of the charges, the facts that you expect to prove, the evidence to support that. And here the prosecutor didn't mention that there was going to be a confession here. We're going to admit this man's confession, correct?
Right,
In her opening statement. So doesn't that support that the people were intending to proceed on the theory that this was an eyewitness case, wasn't a confession case?
Well, the sincerity of the prosecution's statement that she was not definite is not in dispute here, and she doesn't have to be insincere about it for this rule.
Why would she do that up front? I'm not following what your argument is.
Well, I think that maybe the prosecution wanted to keep, their options open, which is entirely fine, but the defense is entitled to do the same thing too. If there's at least a reasonable possibility that this will come in at trial and it is relevant to the case, then voir dire should be allowed. And it's important to note that this is a defendant's full confession to murder. I mean, it's the top count of the indictment to murder too. And the voluntariness of that statement was the defense. It was absolutely critical to the defense. And this is not some law that is easy to follow. This is, can you disregard this incredibly powerful and uniquely overwhelming piece of evidence if you find it to be coerced? This is something that we know
Is
from...
there anything exculpatory in that statement?
Your Honor, it's our position that there is not, and to the extent that there is anything, it is of de minimis value because the statement admits to shooting the victim in the back multiple times as he ran away. Given the duty to retreat, that would not justify a self-defense charge, and it didn't justify one here. Instead, the jury was, defense counsel was precluded from asking any and all questioning as to whether this jury could apply this incredibly difficult law on this determinative piece of evidence against the client.
Would the judge ever have the discretion then to say no to a request to ask the jury if they could follow a particular legal instruction?
If it's an issue or an area of law that is critical to the defense, that is likely to come in at trial, and particularly where a jury might struggle with applying this law, it should be allowed. And this court has said in Boulware and Stewart that, a court's discretion is not boundless, and you have to...
I'm just trying to think of how would we apply this in the future. I mean, critical to the defense. These all seem fairly subjective calls to be made, or discretionary calls, better, by a trial judge. So...
Well, this was an anticipated legal defense. He was challenging the voluntariness of the statement. And in Stewart, this court said that when a court determines the scope of voir dire, it needs to take into account certain factors, such as anticipated legal defenses, how much of the voir dire the court is going to engage into, and the nature and seriousness of these charges.
Right. So I think what I'm struggling with a bit, though, is are we going to have a bucket of potential legal charges that we say, if you ask, you get this question? Or are we going to have ones you always do, and then some you might, and some you don't? It seems to me a hard application going forward, other than discretionary call based on the facts and anticipated evidence and legal issues in the case that's more properly made by a trial court judge conducting voir dire.
Well, Your Honor, if this is going to whether the jury can apply the law in a case that is critical to the defense, relevant to the defense, is likely to come in. This court has already held in Boulware and Stewart that those are precisely the types of questions that are appropriate on voir dire. Counsel should always be entitled to ask questions.
Well, what about a justification defense? What if the defense was justification? Does the court then have to grant a request by the defense counsel to voir dire jurors on their ability to follow that? Even if somebody, did a terrible thing, and but the judge is going to instruct you that there may be circumstances under which that's justified. Can you follow that instruction? Why wouldn't that apply to literally every defensive instruction in the case?
Well, ironically, Your Honor, the court did allow that questioning here, even though the purported self-defense wouldn't have justified a charge. The defense was willing to take that risk that those statements wouldn't come in because it was so likely that they would, that counsel wanted to make sure that anticipated legal defenses were given to the jury. And here, this is not some tangential piece of evidence on some, something that has a remote possibility of coming in. This is a defendant's a confession to murder in his murder trial. And this is an incredibly difficult law for juries to follow. And to instruct jurors at the end of a case, after they have heard and seen the defendant tell them how he shot the victim in the back, and then ask them to apply this law is in abuse of discretion. It infringed on the constitutional right to ensure that your verdict is given by a fair and impartial jury and based on a fair application of the law.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, Lori Farrington for the Office of the Bronx County District Attorney. Your Honors, the
Counsel,
trial...
if a prosecutor does not mention a confession during the opening, does that preclude the prosecutor from submitting that evidence as case in chief?
No, it does not. The issue here is whether the trial court's determination not to allow this particular questioning on voir dire was a reasonable exercise of its discretion, and it clearly was. Now, both Boulware and Stewart stress the broad discretion that the trial court has in determining the boundaries of voir dire.
How come you hadn't made up your mind whether you're going to use a confession made by the defendant by the time you're picking the jury?
Well, there were numerous reasons that the prosecutor might not want to use this statement. First of all, there was the issue of justification and setting up a possible justification defense. And second...
I get that, but what strikes me is that the DAs are always saying, we're not here to convict the defendant. We're here to see that justice is done. And the idea that, well, there's some favorable things in the confession, therefore we're not going to use it, doesn't make sense to me. And I couldn't imagine not putting this on. Now, maybe, as you say, there might be two or three reasons. Go ahead.
Oh, I apologize. The second reason was that it also brought up potentially prior crimes by the victim, which the prosecutor, it's very reasonable to not want the jury to be focusing on whether or not your victim did something 2 years ago.
Wouldn't you have excised that at the time that the suppression hearing was being conducted, or before you want to introduce it, say, Judge, there's stuff in here that shouldn't come into the jury, we'd like to have this excised?
That is a possibility,
okay.
But in this case, the prosecutor wanted to potentially keep the statement out in its entirety. And the First Department made the factual finding that the prosecutor was unsure as to whether or not she was going to use this statement.
Even if we assume that, wouldn't that really be the defendant's call then? I mean, if you're going to ask the question, I assume the concern, and as I read the transcript, is the jury's going to hear about this confession and it may never come in, and they'll be thinking, oh, there's a confession out there. But if the defense is asking for that, who cares if you're going to use it or not? Because they're willing to take the risk that you are, and they want to question the jury about it.
Well, the trial court also had to consider possible prejudice to the people, and now forcing the people's hand to introduce evidence that perhaps they were not planning on doing.
Couldn't the question have been asked in such a way that it didn't suggest that there was or was not a statement, a confession?
Perhaps, but again...
Would that have solved the prejudice to the people problem? Without prejudicing the defendant? In other words, wouldn't that have been a better challenge? Not challenge, balance.
The trial court's concern was exactly what you're saying, getting the jurors not only to speculate about the contents of the statement, but whether or not voluntariness was even going to be an issue.
That's so simple. I mean, there are a lot of ways that could have been done.
There was
Sometimes in these cases, the people have statements by the defendant, and there may or may not be such a statement here, but if there is, could you follow my instructions, so on and so forth. What's the problem with that?
We're not saying that that could not be done. What we are saying is that the trial court's decision in this particular case on these particular facts was a reasonable exercise of its discretion.
Well, that is indeed the question, whether it was reasonable or whether it was an abuse. And what I'm getting at is if it could easily have protected the people from prejudice without leaving it open to possibly substantial prejudice to the defendant, doesn't that make it an abuse of discretion not to do it?
No, because the trial court was concerned clearly that such an instruction would not alleviate the prejudice to the people and would force the people's hand. So in this particular case,
But
that is the
is that a
prejudice.
reasonable concern if it can be properly articulated easily?
I think it's a very reasonable concern.
You could
Yes, I
say,
think-
I ask this question to every juror I, speak to, whether it's a confession case or not. Why would they think that there's anything particular coming in here?
Well, again, as the trial court stated, there's not only the issue of the statement, there's the issue of whether they're even going to challenge the voluntariness of the statement, or whether they are going to challenge the statement in another way. And that was another one of the trial court's concerns in this particular case.
Part of their argument is that it sounds like the judge is favoring the people in this case, because they say, well, it's up to the DA to decide this, and therefore I'm going to impede the defense from questioning these jurors because they have made a decision that's an equivocal one at this point. And it makes it sound like the judge is being unbalanced.
Well, first, we have to remember that there was a very detailed instruction given at the end of the case here regarding voluntariness.
That was
And
at the end.
second-
That was at the end, right?
Yes.
We're still picking the jury.
The issue is
Second-
whether they could follow that instruction. So instruction or not, the issue is whether they could follow it. And that's what defendant is trying to screen for.
Yes, and that was also addressed in the discussion with defense counsel, and the judge specifically said, I'm not seeing any jurors who are expressing any concern with following the court's instructions. And again, there's no bright line rule that if the people say we're not sure we're going to introduce it, that the trial court cannot allow it. But it's based on the facts of every case. And in this particular case, it was a reasonable exercise of discretion. And again, we point to Diaz, which is very similar to this case. And the problem in Diaz was, again, that the court was worried about the speculation of the jurors. And sometimes the trial court may feel that an instruction not to speculate is not enough in this particular case based on these particular facts.
Isn't that exactly the problem here, counsel? You're saying that at the end, the judge gave the instruction about the voluntariness or involuntariness of the statement, and we expect the jurors to follow that instruction. But in the beginning, you don't want to give anything to the jurors because you don't know if they're going to follow the instruction or they're going to speculate or they're going to do something else.
Well, I think the reverse could also be true. If the jurors can follow the instruction not to speculate, why do we have any reason to believe they cannot follow a detailed instruction on the voluntariness of the statement? So I think that argument can cut both ways.
Well, I agree, but that's why I'm saying because the judge's concern about speculation could have been dealt with in an instruction about speculation from the beginning, not wait until the end.
Another factor that was important in the trial court's decision was that the issue of voluntary versus involuntary statements, and I'm paraphrasing the trial court, but was an issue already in the public consciousness, and that he felt that the instruction and the ability of jurors to do that was an issue that had been raised and that jurors do not generally have a problem following that type of instruction.
But it's not merely educational, it's to confirm, right, that the jurors will not let their understanding or misunderstanding impede their ability to deliberate in a way that's fair and just.
Yes. However, again,
So what I'm saying is, you can know a lot of things.
I'm sorry?
Right? Any prospective juror can know many things, right? We can assume they know a great deal of things, but that doesn't mean that a judge doesn't go through the exercise of asking questions and inquiring.
They do, and in many cases they do, but again, they have the discretion to determine what is relevant, what the prejudice to each party might be, and what outweighs, whether the value of that question outweighs the potential prejudice to one of the parties. And he also mentioned potential prejudice to the defendant. Would the jurors speculate that this was an inculpatory statement, therefore being kept out by the defense? And the trial court weighed the prejudice versus the value of asking the question, and in its discretion made this determination.
And should the judge do that if the defendant has already made that calculated risk?
Yes, that is the job of the trial court, and that is mentioned in, I believe, Stewart and Boulware, that the trial court's function is the same as it is during trial, to weigh the prejudice versus probative value. And that's exactly what the trial court did here. And again, at the end, gave a very detailed instruction about which the jurors had no questions. And also in this analysis, there was no prejudice to the defendant. And it is clear that you need prejudice to the defendant based on Jean and Stewart, excuse me, and Pepper, and there was no prejudice here.
Thank you, Ms. Farrington.
Thank you.
Ms. Main?
Your Honors, when the court said he wasn't seeing any jurors that wouldn't be able to follow these instructions, no questions had been asked on voir dire yet. And the reason that this could be in the public consciousness is because false confessions are one of the leading causes of wrongful convictions, which shows that
But
jurors...
all of that can be argued, and isn't Ms. Farrington right that you've got a jury that, you started out by saying this is a very difficult area of the law, and it is. So why wouldn't we leave it to the judge and let the confession come in or statement come in or come out, and then let the judge handle it after it's been in and at the time before the jury deliberates?
Because by the time that you ask the question after the statements come in, you have no idea whether that 1 or 12 of those jurors are of the mindset that I don't believe someone under any circumstances would confess to something they didn't do, or I might be able to think that a statement is coerced, but if I believe that it's truthful, I'm not going to be able to disregard it, and that's what the law requires. So, under these circumstances, for the court to just choose to suppress the constitutional right to ensure that these jurors could follow this law in favor of the fear that there might be potential juror speculation in the unlikely event the statements don't come in is an abuse of discretion. And I'm unclear what prejudice how that prejudice would go to the prosecution. If
You know, in federal court, I have an unfairly good advice that they don't let you talk to the jurors at all. I mean, the court does it all, and asks all the questions. And so in terms of a constitutional right to talk to the jurors, it's not that.
Right. Well, in fact, Your Honor, the defense counsel said, I would like you to ask the jurors, or maybe I could do it. So, he asked if the court could just instruct the jury, in the same way that it had done previously, just to ensure that those jurors who could not disregard a confession, even if they found it to be involuntary, were not on the panel that decided whether this person was guilty of this crime.
Thank you, counsel.
Thank you, Your Honors.